In this video, I will be sharing with you certain such important legal principles which, if you already know, will help you understand whether the procedure that is followed in your case or cases before the administrative authorities is being rightly followed or not, and where the administrative authority is committing a mistake which may give you a right to challenge the decision of the administrative authority in superior courts for the reason that the authorities have violated these important legal principles. इस वीडियो में मैं आपके साथ शेयर करूंगा वो महत्वपूर्ण लीगल प्रिंसिपल्स जो अगर आप पहले से ही जानते हो तो आप यह समझ सकोगे कि आपकी जो भी केसेस चल रही है एडमिनिस्ट्रेटिव अथॉरिटीज़ के सामने, उन केसेस में एडमिनिस्ट्रेटिव अथॉरिटीज़ क्या सही प्रोसीजर फॉलो कर रही है या नहीं, और अगर नहीं तो आप उन केसेस में आने वाला डिसीजन उन प्रोसीजरल डिफेक्ट्स के वजह से सुपीरियर कोर्ट्स में, मतलब कि हाई कोर्ट में या सुप्रीम कोर्ट में चैलेंज कर सकोगे और आपके चैलेंज में दम रहेगा. हेलो दोस्तों, आई वेलकम ऑल द न्यू सब्सक्राइबर्स ऑन दिस चैनल. जो इस चैनल पर नए हैं उनके लिए मैं बता दूं, my name is advocate Nahush Khubalkar and I have been practicing as a lawyer, as an advocate, mostly before High Court at Nagpur since last 31 years. You are all welcome to explore this channel and I have already uploaded a lot of content on this channel जिसमें आपको कई सारी प्रोसीजरल बातें, कानूनी बातें, ऐसी जानकारी जो कि आपको कोर्ट्स में आसानी से नहीं मिल सकती वो पता चलेगी. This video is for all, for general people as well as for young advocates. Because young advocates, if they know these legal principles which I'll be sharing, will be better equipped to raise appropriate challenges, appropriate objections, and appropriate grounds, either before the lower authorities or before the superior courts like high courts or supreme courts. Examples are many in which, merely for violation of these principles, the superior courts have quashed the judgments of the lower authorities like quasi-judicial bodies or tribunals or administrative authorities. Such is the power of these principles. So friends, you must be wondering which are these principles. So without holding your suspense for long, मैं आपको बता दूं कि इन principles को कहते हैं the principles of natural justice. Now I know many of you have heard of this phrase and maybe you are all aware of these principles, but still this video will be useful. Now first things first, what do principles of natural justice mean? So friends, as the name suggests, the principles of natural justice are those principles which are assumed to be there in every law in the country, even if they are not written. They are all the principles of fairness. Fairness must be there in every procedure that is undertaken by the administrative bodies, administrative authorities, quasi-judicial bodies or tribunals or courts. So these principles of natural justice are so important that the courts have held, the Supreme Court has held that even if the law does not make a mention of them, they are always to be understood to have been written into those laws, to exist in those laws. They need to be read into those laws, even when they are not specifically written either by the parliament or by the state legislature or any other government. Because these are principles of natural justice, they are supposed to be there in the nature, everywhere in the nature, in every particle, in every space. They are assumed to permeate everywhere in the nature and also in the conscience of those who run the administration, who deliver judgments, means judges, the administrators, the judges, the presiding officers of the tribunals, and all those functionaries who are associated with running the government. So all of them are assumed to know these principles and are expected to follow them in the procedure in the cases which they are dealing. Second most important thing you must understand is that ये principles सिर्फ एडमिनिस्ट्रेटिव एक्शन या स्टेट एक्शन या क्वासी जुडिशियल बॉडीज, अथॉरिटीज और ट्रिब्यूनल्स वहीं लागू है. सो व्हाट आर दीज प्रिंसिपल्स ऑफ नेचुरल जस्टिस, दीज प्रिंसिपल्स ऑफ फेयरनेस? सिंपल. फर्स्ट प्रिंसिपल आई विल टेल यू. मान लो आपके दोस्त के साथ झगड़ा हो गया और आपके माइंड में कोई बात है जो आप उसे समझाना चाहते हैं और वो समझे बिना उसने आपके साथ बात करना बंद कर दिया. तो आप क्या करोगे? आप उसको अपनी बात बताने की कोशिश करोगे और वो जब तक उस बात को सुनेगा नहीं, उसको समझने को तैयार नहीं होगा, आप अपनी बात कितनी भी कहोगे वो कम्युनिकेट नहीं होगी. तो आपके दोस्त ने आपकी बात सुनना, खुले मन से सुनना, ये एक प्रकार से प्रिंसिपल ऑफ नेचुरल जस्टिस है. मतलब कि अगर आपका दोस्त ओपन माइंड से आपको हियरिंग देता है, हियरिंग इज़ द वर्ड, वो देता है, तो आपका मन उसके सामने खोल कर रख सकते हो, आपका विचार उसके सामने पहुंचा सकते हो और उसकी जो मन में कोई गलत कल्पनाएं होंगी, if he has some misgivings or misunderstandings about whatever happened between you, that may be cleared. This can happen through the process of hearing. On the same lines is the first principle of natural justice. The principle which says that before coming to adverse conclusion about anybody, against anybody, that other party must be heard, or he must be given at least an opportunity to be heard. तो हियरिंग की संधि देना, या अगर वो संधि वो उपलब्ध करता है तो उसको हियर करना, ये एक महत्वपूर्ण प्रिंसिपल ऑफ नेचुरल जस्टिस है, नैसर्गिक न्याय तत्व है. मुझे अभी हिंदी वर्ड याद आया उसका. The principles of natural justice are called in Hindi नैसर्गिक न्याय तत्व. कितना सुंदर शब्द है. So the first principle is the principle of audi alterum partem. ये कोई ग्रीक या लैटिन फ्रेज है जिसका मतलब है hear the other side first before coming to any adverse conclusion about that other side. In the example of your friend is expected to first hear you, understand your viewpoint before coming to an adverse conclusion against you, before deciding to sever the relationship with you. So if he hears, you may open his mind. In the same way, if the quasi-judicial body or tribunal or the administrative officer who is likely to draw an adverse conclusion or likely to take an adverse action against you is first expected to give you a hearing, to understand you, to hear your viewpoint, and then apply his mind to that, and then decide whether he should really come to the adverse conclusion against you or not. This is the principle of fairness. It's very, very, very important, my dear friends. इसीलिए तो केसेस चलती है हियरिंग पर. बहुत सारी केसेस में only because the administrative authorities or the bodies have not given the opportunity of hearing to the person affected by the decision, the superior courts like high courts or supreme courts have quashed, and in regular course they come across such cases and they do quash such decisions which are rendered without giving the opportunity of being heard. इतना महत्वपूर्ण है ये फर्स्ट प्रिंसिपल ऑफ नेचुरल जस्टिस, द राइट टू हियरिंग एंड द राइट टू बी अफोर्डेड विद एन अपॉर्चुनिटी ऑफ हियरिंग, मतलब उसी का एक डायमेंशन है, either to hear him or to afford him an opportunity of being heard. Of course, after giving an opportunity of being heard, if the person doesn't appear and doesn't choose to argue the case or put forth his viewpoint, that is his choice, it can't be helped. Then the authority will proceed even without hearing the party. But if that opportunity is also not given, then that decision is likely to be quashed, is vulnerable to quashing. So that was first. Second, the other finer aspect of this principle is that the party against whom an action is proposed must be first given a notice of charges which are against him, with an opportunity to give his explanation. Are you getting me? First, there must be a show cause notice, or maybe a charge sheet, or maybe something that contains allegations against him. And that notice must be served on him. It must be ensured that the notice reaches him, and also that he must be given an opportunity to explain that through his reply. This is another facet of the principle of natural justice. Because if directly an action is taken against someone without giving him the show cause notice, then there is a violation of fairness, because you are taking arbitrary action, one-sided action, without even knowing what could come from him in the form of a reply. And when the reply comes, and after you apply your mind to the reply, maybe you would change your mind. You would refrain yourself from taking adverse action against that person. Adverse action could be anything. It could be imposing a punishment, it could be stopping his salary, it could be auctioning his property, it could be anything in the public domain. So before that person is put to some loss or harm, this opportunity of explaining must be given. इसी principle का एक और facet है कि after hearing the party, the action that is taken against him must be in the form of a reasoned order. एक पूर्ण विचार किया गया आदेश के द्वारा ही उसके खिलाफ एडवर्स एक्शन ली जानी चाहिए. An unreasoned order is vulnerable to challenge before the High Court or Supreme Court. So the authority who is taking adverse action against that person must discuss and analyze the facts and circumstances of the case and his reasons as to why he is coming to a conclusion regarding the adverse action that is to be proposed against him, that is directed against him. So the order must be a reasoned order with full application of mind. And why should the decision be a reasoned one? Simple. It's for two reasons. Firstly, the person against whom the decision is taken should be in a position to understand as to why that decision is taken against him. Here comes a finer aspect of right to know. He must be in a position to understand and know why that decision is taken against him. That is one. And second, whenever he challenges that decision before the superior courts, the superior courts should also be in a position to understand the mind of the lower authority, so that the superior court, means High Court or Supreme Court, are in a position to judge whether the reasoning given is logical, legal, fair, correct, proper or not. So without a reasoned order, it is not possible for the higher courts to understand and take a decision about the correctness or otherwise of the decision of the lower authorities. Therefore, whenever the lower authorities deliver a cryptic decision, cryptic means समझ में नहीं आएगा ऐसा, रीजन्स ही नहीं रहते उसमें, या रीजन्स होंगे तो भी नाम के लिए कुछ रीजन्स होते हैं, या ऊपरी ऊपरी दिखाया जाता है कि रीजंस है बट रीजंस कुछ नहीं होते, ऐसे क्रिप्टिक डिसीजंस। क्रिप्टिक यानी ये शब्द बड़ा मज़ेदार शब्द है, गुप्त। क्रिप्टोग्राफी आपको पता है ना, यानी गुप्त लिपि शास्त्र। तो गुप्तता जहाँ होती है वहाँ क्रिप्टिक कहा जाता है। तो इस टाइप का डिसीजन जो रीजंस रिवील नहीं करता उसे क्रिप्टिक डिसीजन बोलते हैं। सो क्रिप्टिक डिसीजन देना, this itself becomes a reason for quashing that decision, and the higher courts then send the matter back to those authorities for passing a fresh order after recording proper reasons. That happens, and that is the importance of delivering a reasoned order. So all these things are there included in the very first principle of natural justice. Here the other side. So एक प्रिंसिपल के इतने सारे फैसेट्स हैं। जब हियर द अदर साइड हम बोलते हैं तो उसके पहले आता है नोटिस, अपॉर्चुनिटी टू एक्सप्लेन, देन उसका रिप्लाई। वो रिप्लाई अगर समाधान कारक नहीं है तो अपॉर्चुनिटी ऑफ हियरिंग। हाँ, कुछ नियमों में प्रिंसिपल्स ऑफ नेचुरल जस्टिस कैसे फॉलो किए जाएंगे ये स्पष्ट रूप से दिया होता है। वेरी स्पेसिफिकली इट इज स्टेटेड इन सर्टन acts or rules, but wherever it is not so stated, they are to be read into it, they are to be understood into it. So these are the minor and important facets of the first principle of natural justice, audi alteram partem. I was talking about that, a reasoned decision. I know I am repeating a bit because things should get clearly into your mind, your head. You should understand. Therefore, a little repetition, please tolerate me. So this is a very important first principle of natural justice. Coming to the second important principle of natural justice. Nemo judex in causa sua. Now this is again some Greek or Latin phrase. उसका मतलब है कि no person shall be a judge in his own cause और own case, जो भी है। इसका सिंपल मतलब है एब्सेंस ऑफ बायस होना चाहिए। हर एडमिनिस्ट्रेटिव एक्शन में, हर क्वासी जुडिशियल एक्शन में या जुडिशियल एक्शन में देयर मस्ट बी एब्सेंस ऑफ बायस। नाउ इन एडमिनिस्ट्रेटिव लॉ और इन द लॉज दैट वी लर्न देयर आर डिफरेंट टाइप्स ऑफ बायसेस। देयर इज पर्सनल बायस, there is official bias, and there is, say, pecuniary bias. Bias matlab some connection with the subject matter of the case, or some connection with the persons involved in the case, or some connection with the monetary aspect that is involved in the matter. So these types of biases are with regard to those different aspects. If any of these kinds of biases are existing in that kind of matter, the officer who is taking a decision, it could be the high level administrative officer, it could be the presiding officer of the quasi judicial body or tribunal, or even a judge, should recuse himself from that matter to avoid any simple chance of not taking a neutral decision. So wherever there is a possibility of not delivering a neutral decision, not taking a neutral decision because of interest of someone important involved in that matter, especially that of the decision making authority. Maybe that decision making authority is connected to, say, an interviewee. Suppose the interviews are going on for selecting some candidates for a particular post. And in that selection committee, the interview panel, there is an officer who is connected with some candidate who appears for interview before that panel in which this officer is included. Then the element of bias comes in. The mere possibility of bias is also to be frowned upon in law. Law frowns upon it. So इस तरह की situation अगर है तो ये गलत है, and that is a clear violation of the second principle of natural justice. So friends, whenever you are involved in some cases in which such things are happening, you can understand that the things are not going right. And to my young advocate friends, whenever you study cases for filing before the High Court or Superior Court, Supreme Court, while studying that matter and after taking instructions from your clients, you can make out whether the principles of natural justice are violated or not. And if yes, then exactly which principle. You can then raise a ground in your petition for challenging that order. And in every likelihood, you will get a favorable order from the Superior Court, maybe only on the basis of that ground of violation of principle of natural justice. Now I know this subject is very, very vast. Actually so vast that it can take up hours and hours of lecture. And that should not even be the purpose of a YouTube video, because the more succinct, the better. The more simpler, the better. The more easy to understand, the better. And that has always been my attempt on this channel. The very objective of this channel is to bring the principles of law which are there in the cobweb of complicatedness to my audience in a very simpler form and very easy to understand form. Before closing, I must also make one thing clear to you. There are exceptions to the principles of natural justice also. There are exceptions to the principles of granting hearing, the principle of bias. It is held by the Supreme Court that the principles of natural justice are not a straitjacket formula. मतलब कि कोई भी सिचुएशन में ये प्रिंसिपल वायोलेट हो गए तो वो क्वैश होना ही है, वो जजमेंट क्वैश होना ही है, ऐसा नहीं है. देयर इज़ अ वायोलेशन ही है, ऐसा नहीं है. The courts have said that the facts and circumstances of the case are also to be seen. For example, I am recently conducting a case on behalf of university. In that case, the employee of the university who was terminated few years back had challenged his termination before the college tribunal. And after hearing the parties, the college tribunal came to a conclusion that, that conclusion was recorded on the basis of record, that the employee had consistently confessed about his guilt 4 times. And therefore, it was really not necessary to conduct a full-fledged inquiry for complying with the principles of natural justice. The tribunal held that principles of natural justice are to be applied by taking into consideration the facts and circumstances of the case. Now, of course, there are judgments of Supreme Court also supporting this view, especially the view that wherever there is an admission of guilt in a departmental inquiry and the employee is consistently admitting it, not some stray admission, a consistent admission of guilt, and in our case the admission of guilt is 4 times. So there is a consistent admission of guilt. In that case, not holding a full-fledged departmental inquiry is not fatal to that employee. Now that employee has challenged the judgment of the college tribunal in High Court and a writ petition is pending. The hearing of the petition is going on. I have been raising these points before the High Court that not conducting a full-fledged inquiry is all right, because in the circumstances of the case, it was really not necessary, and it sufficed that the employee was given a fair opportunity to put forth his say. And whenever such opportunity was given, he always came up with admission of his guilt and requesting for exoneration. So, the point that I want to tell you is that principles of natural justice also do have exceptions. They are not there as straitjacket formula. But in majority of cases, the situation is such, this I'm telling you on the basis of my experience. In majority of cases, the facts and circumstances do show that there was real violation of principle of natural justice, and the superior courts, high courts, do quash the judgment on the ground of violation of such principles. That happens. The cases involving exceptions are less in number, but they do exist. तो क्या आपने इस चैनल पर मैंने जो प्लेलिस्ट्स अपलोड करके रखी है हिंदी भाषा में कानून की जानकारी या क्वेश्चन एंड आंसर्स या और कुछ जैसे कि मोटिवेशन फॉर यंग लॉयर्स, वो सब देखे कि नहीं? इफ नॉट, please watch. Okay, so that much for today, and I hope you have now understood at least the fundamentals of the principles of natural justice.